Welcome to the Contract Law 2 course at the University of the West Indies Faculty of Law. This lecture is on remedies in contract law. Here's an overview of what will be discussed in this lecture. First of all, I'll give a brief introduction to remedies in contract law. Then we'll move on to common law remedies, which are the ones you're probably most familiar with. Essentially, those are damages. We'll then move on to equitable remedies, which include specific performance, injunction, and rescission. There are, of course, more equitable remedies available, but those are the ones on the syllabus, and so we will limit ourselves to discussing those. Lastly, we'll discuss quasi-contractual remedies before we move on to the summary. In essence, there are three types of remedies. There's remedies at common law, remedies in equity, as well as remedies under legislation. Now, as you'll be familiar from all the various types of law that you study, legislation tends to trump common law, and so it is here as well. So where there are remedies under legislation, those trump the remedies which might be available at common law or in equity. Now, another rule is that equitable remedies are only available if the common law remedies are not sufficient. And we have a case for this, which is Flint and Brandon. So what happened in Flint and Brandon is that Brandon was a landlord and he leased some land to Flint. Now, it was agreed that the land would be in a certain condition, and as it turns out, the land was not in that condition. Now, Flint claimed for specific performance, which we'll get to later, but essentially that's an equitable remedy. And the court said, no, Flint, you can't have the equitable remedy, you cannot have the specific performance, that means to receive the land in the condition as agreed, because damages, money, could have made up for fixing those problems. So, in other words, Flint was entitled to damages in respect of making the land or putting the land in the position that it should have been under the contract, but he was not entitled to specific performance because in that case, the common law remedy was sufficient to fix the problem. So we only revert to the equitable remedies if the common law remedies are not sufficient, are not good enough, cannot help us fix whatever the underlying problem is. There are also quasi-contractual remedies, which, as the name suggests, sort of exist outside the sphere of the contract. So sometimes we might have a situation where on the facts there is no contract, but there should still be a remedy available, and so the law sometimes creates a remedy in those circumstances. So essentially those are the areas we're going to look at: common law remedies, equitable remedies, as well as the quasi-contractual remedies. Let's begin by looking at remedies at common law. In essence, remedies at common law are damages. Now, I put up the word damages, but damages can be broken down into various forms of damages. So there are compensatory damages, punitive damages, incidental damages, so all sorts of damages that you may think of when you think of damages. But in essence, that is what is remedies at common law, it's damages. Now, by their very nature, damages are compensatory. Now, this was nicely expressed in the case of Robinson and Harmon, where the court said that damages are supposed to put parties in the position they would have been in had there been no breach of contract. What happened in Robinson and Harmon is that Robinson leased some property from Harmon. And Harmon said that this property was his and he was able to let it out to Robinson. Now, as it turned out, Harmon was not actually the legal title holder of that property. He was merely a beneficiary under a trust. Now, trust law is a separate topic. We don't cover that here, but imagine it as if Harmon had some interest in the property, but he certainly did not have full rights over the property, and he was certainly not entitled to rent out the properties to someone else, which is what he did when he rented it out to Robinson. Now, as a result, Robinson was not able to take possession of the property because essentially it belonged to someone else, namely the trustees, not Harmon. So what happened then was that Robinson sued for compensation, and the court sort of had to figure out what sort of compensation might be available here. Now, specific performance, that's an equitable remedy, we'll get to that later, is basically something that tells a party to do something specifically. So the court tells a party to do a particular thing, such as hand over the property to Mr. Robinson in this case. But of course that's not possible, that's not available because Mr. Harmon doesn't own the property, the legal title is with someone else. So the court found another way of assessing the damages, namely what would it cost for Robinson to get another property, which then turned out to be a lot more expensive, as opposed to the original agreement between Robinson and Hammond. But that difference, in essence, the difference between what Robinson would have paid under the original contract and what he ended up paying, was what the damages were. In addition, there may be damages, and indeed in this case there were damages for loss of income, loss of profits, because Robinson wasn't able to use the property at first. Well, not at all, until he got some alternative. So, in essence, that's what damages are about, trying to put the parties in a position as if the breach hadn't happened in the first place. Now, that assessment may not always be easy. In fact, the assessment is usually very difficult. Now, sometimes it's easy because there is something that in a contract that's broken or that needs to get fixed, and then you can just get it fixed, and then there will be a cost associated with that, and there's an invoice, and then the invoice will tell you whatever the damages are. But usually it's not that easy. So usually you have to do a bit of guessing. Now, is that allowable? Yes, it is. So the assessment of damages may be proximate, so you don't have to assess it 100% exactly. There's a nice Australian case on this, Pennant Hills Restaurants and Barrel Insurances. What happened in that case was that the restaurants, Pennant Hills Restaurants, they were supposed to be insured for liability in case their workers got injured on the job. And the insurances, Barrel Insurances, they were the party who were supposed to arrange that insurance. But Barrel Insurance did not do what they were supposed to do. And so the liability fell on Pennant Hills to pay for workers' compensation, which they thought they had been insured against. Anyway, the court held that indeed Pennant Hills was excused and Barrel Hills had to pay that compensation. But the point made in that case was that sometimes it's not easy to assess the compensation. So if a worker is off work, how long are they going to be off work? Now, the court doesn't engage in ongoing assessment. Whenever the judgment comes down, there will be one sum, and that will be the final sum. So the court has to sort of make some prospective judgments as to what someone might be entitled to going forward through loss of income, loss of earnings, all sorts of things to compensate, for instance, in Pennant Hill, an injured worker. Now, can the court know for sure that that worker will be back at work in 6 months or in 12 months? No, we don't know. We have to look at the evidence on the medical side. We have to look at whatever we can. But we can't be sure. But the court does need to, at the end of any proceedings, come up with a particular number. And so there's a bit of guesswork involved in that. So sometimes someone may be compensated for, say, 12 months of not working, and then after a time that is shorter than that, they are able to go back to work. Well, then they got lucky. Could, of course, work out the other way as well. So there's a bit of guesswork involved, but generally that is allowable. Now, within the sphere of remedies at common law damages, we have something called expectation interest, or sometimes also called performance interest, and we have something called reliance interest. So what are those things? What do they mean? First of all, expectation interest or performance interest. That happens when there is a loss of benefit to the injured party where there's a breach of contract. Now, Ruxley Electronics and Construction and Forsyth is a very interesting case, which details this, but it also shows you that sometimes where there's a breach of contract, you cannot demand to get the entire contract re-performed in the way it should have been performed. So, in a sense, it's a slight variation on the idea that the damages are designed to put people in a position as if the contract had been performed. So what happened in that case? What happened in that case was that Ruxley was supposed to build a pool for Forsyth. Now, the pool was supposed to be around 7 feet deep, but instead, Ruxley built a pool that was only 6 feet deep. Now, the court looked at the issue of whether that really made a big difference. So, for instance, could you still dive in the pool without hitting the bottom, even though it was 1 foot shorter or less deep than it should have been? And what the court at the trial found, so the trial court found that Forsyth was not entitled to have the whole pool rebuilt. So instead, what Forsyth had lost was mainly amenity. So there was some benefit that was lost because the pool was no longer as deep as it should have been. But he was not entitled to have the entire pool rebuilt, which would have cost something like £22,000. Now Forsyth appealed, and on appeal it was held that he was indeed entitled to have the whole pool rebuilt as it should have been built in the first place, at 7 feet deep. And then the matter went to the House of Lords, and in the House of Lords the court decided that basically the trial court was right in that Forsyth was not entitled to have the entire pool rebuilt, but only entitled to damages in the form of loss of amenity, because he had lost some of the benefit of the pool because it was no longer as deep as it should have been. And the amount was something like £2,500, so roughly about 10% of what it would have cost to rebuild the pool altogether. Now, reliance interest is where you claim damages for expenses that you incurred in relying on the contract. Now, a great case for this is Anglia Television and Oliver Reed. Now, Reed was an actor, and an American actor, and he was supposed to come to England and be in a TV series for Anglia Television. So there was a contract between these two parties. And Anglia Television had set about to design a set and sort of prepare for the filming of this series. But before the filming started, so before Reed ever arrived, Reed cancelled the engagement. Now, at that point, Anglia was faced with some choices. What could it sue for? Well, it could sue basically for damages in terms of loss of profits, because Reed never showed up, the show was never filmed, and so that might have led to some loss of profits. But as we know in TV, it's never quite sure that your show will actually turn a profit. It would have been very difficult for Anglia to show that indeed they would have earned so and so much money, and then that they could have claimed so and so much money in terms of compensation because of the loss of profit. So instead, Anglia did something different. What they did is they sued on the basis of reliance interest, that they had relied on the contract going ahead as planned and on Reed showing up, and in the process of relying on it, they had spent money, which they had in terms of preparing for the show to be filmed. So they had spent money on designing a set and getting it all set up. So the court agreed that Anglia was entitled to get compensated for all those expenses incurred in basically preparation of performance of that contract, which would have been the filming of the TV series. When we deal with damages, and when an innocent party is wronged because there's a breach of contract, and say they terminate as a result of that, can they then just sit around and let the damages accumulate? No, they cannot. So once a contract comes to an end through a breach, then of course damages may be payable to the innocent party. However, the innocent party has a duty to mitigate. What does that mean? Well, in a strict sense, it's not a duty in the sense that the innocent party has to do something. However, if the innocent party does not do something, and that something is to mitigate, then the amount of damages may be reduced. It may be even reduced to zero, depending on the circumstances. So the failure to mitigate may affect the award of damages. And this is what happened in Pezu and Saunders, which is a case involving sellers of silk and buyers of silk. And the sellers had agreed to sell at a discounted price, but the contract ran for 9 months. So for every month, the deliveries were going to be made, and then the buyers had to pay. Now, right after the first month, the buyers were late in paying. That in and of itself was not a reason to terminate, but the sellers were a bit suspicious, so they said, all right, we'll continue with what we did, but in future you'll have to pay us in cash, which the buyers didn't want to do. So then the buyers went out and obtained the goods at a higher cost and basically tried to claim the difference, and claimed that the sellers had terminated the contract by not delivering unless they were paid in cash. Now, the court held that the demand to pay in cash was not unreasonable, and what the sellers did was therefore not unreasonable. However, the buyers, being faced with an offer which was not unreasonable, then having not taken up that offer and gone elsewhere and bought their goods at a higher price, were not entitled to claim the difference. Also, that goes hand in hand with duty to mitigate, you must take reasonable steps. So whenever this duty to mitigate arises, the court basically sees or asks what would a reasonable man have done in those circumstances. So in British Westinghouse and Underground Electric Railway, this was a contract for the sale of turbines, and the turbines were delivered. However, they were not the right turbines. The turbines that were delivered were underpowered compared to the turbines that should have been delivered. So the buyers reserved the right to claim for damages, but they did accept the turbines nonetheless. Later on, they replaced these turbines, which were not up to scratch or were underpowered, with other turbines from a completely different person or a different company. And those new turbines were much more powerful than the original turbines should have been. So essentially now we have turbines that were not very powerful, turbines that were sort of quite powerful. Those were the ones that should have been delivered under the original contract, and turbines that are much more powerful, which is basically these are the turbines that the buyers bought from somewhere else in order to replace the turbines which were not as powerful as they had contracted for. And then they tried to claim the price of those replacement turbines as damages, and the court said that that was not reasonable. So at most, they could have replaced the underpowered turbines with turbines that had the same power that they should have received as part of the original contract. Now, they could still perhaps have claimed some damage or received some damages, because even though they had replaced the turbines with much higher power turbines, the fact that they would have had to replace them, that remains the same, because the turbines that were delivered were just not right. However, because they're high power turbines that they in the end got somewhere else, because those turbines led to a much more effective operation and savings in terms of their costs, when you looked at all the numbers, it turned out that the buyers were actually better off now than if they'd had received the turbines that they had originally contracted for. So again, the court said that was not reasonable to replace the turbines that you were supposed to receive with much better ones. So in the end, they were not entitled to any damages. They did not receive any damages.